Okay, well, thank you, Kevin. I guess on the topic of working human, I got up this morning, I put on an Oxford shirt, jeans, docksides, and my wife asked me, why are you so dressed up today? So I guess that's a sign of the times that in this remote world, an Oxford shirt and jeans constitutes formal business wear. What I wanted to do today was to take some time to talk about President Biden's philosophy concerning unions. And in connection with that conversation, I want to spend a lot of time on the PRO Act, which is a piece of legislation that I think really encapsulates President Biden's philosophies about where he would like to take unions under the National Labor Relations Act. And it's very, very far from where we are right now. So Amy, could you take the next slide, please? Okay. I think when you look at administration selections, you get a peek into the philosophy of the president. If you think back to President Clinton, his Secretary of Labor was an academic, Robert Reich, I believe, an academic in that role. President Biden instead chose Marty Walsh. Marty Walsh right now, or within the last few months, was the mayor of Boston, a very, very strong union town. More importantly, Marty Walsh was the head of the Building and Construction Trades Council in Boston, which means that is an umbrella group that speaks for trade unions in Boston. And I think President Biden's selection of Marty Walsh was symbolic as much as it was a practical response to where he wants to take the Department of Labor. Under President Trump, the National Labor Relations Act and the board that administers it really had a pro-employer lean to it. And for those of us who practice on the management side, it really was a good 4 years to be a management side labor lawyer. With President Biden, we can expect to see a shift towards much more friendly policies towards unions, unionization, and frankly, union access to employer assets. For example, there was a case called Purple Communications under the Obama administration, which essentially allowed use of employer email systems for union organizing activity. We can rest assured that President Biden will return to that philosophy. And the reasoning is something that goes along the following lines, that if you can use an employer email system for other non-business uses, whether it's to solicit for a charity, then you can use them for union organizing as well. We also came to learn a term under the Obama administration called ambush elections. Back in the good old days, pre-2008, the election cycle from the filing of a petition for a union election until the actual election date typically ran 42 days. And during that 42-day window, you could educate the people who would vote in the union as to what it was all about. The Obama administration shortened that time window to as few as 11 days, but typically it's more in the 20-day range. But the sum and substance of that is things happen very quickly. They happen quickly by design, and they happen quickly because the administration does not want the employer to react and fight off the union organizing effort. The third thing I think you'll see is an easing of restrictions on giving non-employee union organizer access to an employer's property for the purpose of organizing. Under the Trump board, the fine line between personal property rights and private property rights and union organizing activity were very clearly defined. You could ask a union organizer to leave the property. I think under a Biden board, you're going to see a lot more deference paid to union organizing rights over private property rights. And finally, I think you'll see a return to a far less stringent joint employer standard. So for those folks on the call who might use temporary workforces, which probably is everyone, there might be an easing of restrictions to have we as the hirer of the contractor be deemed the employer for the temporary employees. What does that mean as a practical matter? That means that they can organize a union on your watch and negotiate terms with you. Okay, this is a pretty good midpoint to describe what we anticipate the Biden board will do by rule and by philosophy. And what it really means for the folks on the call here is you cannot wait for things to happen to you. You have to proactively understand the environment that you're in and take steps to train up your supervisors to make the work experience better for people so that union organizing activity are less likely and your chances of successfully defeating it are greater. So this is an area where you train when times are quiet. The old expression is repair the roof when the sun is shining. That is very true for training supervisors to avoid unions. Next slide, Ian. Okay, here is a piece of legislation that has already passed the House of Representatives. You have a 50-50 tie in the Senate. And if this piece of legislation gets to President Biden's desk, he will have his pen ready and he will sign it before he even gets to read it, because it will fundamentally transform labor relations in the United States of America in such a dramatic way. We will have never seen anything like it before, and we will never see anything like it moving forward. What I'm going to do now is to walk through the various elements of the PRO Act so that you can bug the hell out of your senator so that they are not inclined to sign or sign on to this piece of legislation. The first thing the PRO Act would do is to eliminate right-to-work laws. Now, what are right-to-work laws? Under the National Labor Relations Act, each state can basically pick whether it's going to be a right-to-work state or a non-right-to-work state. In non-right-to-work states, people can't be forced to join a union. Right now, there are currently 26 to 28 right-to-work states in the country. They are the states where their economies are booming. They are in the South, the Southwest. They are doing so well that former Rust Belt states like Indiana, Michigan, are now have already signed on to become right-to-work states themselves because they're losing too many jobs to the South and Southwest. What the Biden administration wants to do is to strip states of that right to become right-to-work states. And frankly, I think that would be devastating to the economy. It will be devastating to the United States. Now, in our region, Pennsylvania, Delaware, New Jersey, all are non-right-to-work states. As a fun fact, I think there are approximately 13 states that have at least one Democratic senator, which means there's going to be tremendous political pressure on them to sign this piece of legislation, despite the fact that it's going to hurt their states. So the other thing the PRO Act will do is allow for more picketing and strikes. For those in the crowd who might be construction contractors, you're well familiar with this. You have the non-union sub on the job, the pickets show up, and they're picketing that non-union sub. And the non-union sub is the object of the picketing. What the PRO Act will do is allow for what's called secondary picketing, where you essentially direct your picketing activities at a third party in the hopes that that third party will be discouraged from doing business with the non-union entity. Let's give a retail example. Let's say that XYZ trucking company is a non-union trucker. The Teamsters take a dim view of that, and they will now deliver to your retail store. Well, under the PRO Act, the unions could picket your retail store in the hopes of discouraging you from doing business with that trucking company. So that is a very dramatic change in the current law. Next slide, Ian. The other dramatic change that the PRO Act presents is the elimination of an employer's right to permanently replace economic strikers. Let's say that an employer and a union negotiate for months and months and months, and they don't get a contract. And the union says, we've had enough. We're going to call a strike. That McDevitt employer, he's a cheapskate. We're going out. So they can call an economic strike because they're saying, we're not going to work for what McDevitt is offering. So what McDevitt can do in that situation, he can put an ad in the local paper and hire people to permanently replace the people who go on strike. And that means they can lose their job completely. The only preference they would be given is if we were to hire in the future, we would have to give them some preference in terms of who we would hire. Under the PRO Act, we would not be able to permanently replace people such that once the strike ends, all those people that you've hired, they could be bumped out of jobs. Okay, next slide. This is perhaps among the most significant. For the first close to 175, 80 years of the National Labor Relations Act, there were no, it's what's known as an equitable statute, which means you can't give money judgments or other things as a result of violating the statute like you can for Title VII, race discrimination claims, or things of that nature. Now, the Labor Board can order back pay in certain circumstances, but it primarily was a statute designed around telling people what you can't do once the board has concluded that you have done something wrong. The PRO Act would fundamentally change that such that you could impose civil penalties, liquidated damages, which were often twice the economic damages that someone suffered. And what's most dramatic in my view is directors and officers could be held personally liable where they directed or committed the violation. So that will be just a very, very dramatic change in the law, such that if you're a director or an officer, you might think twice as to whether or not you want to serve in that role, given the personal exposures that might pop up. The next thing that the PRO Act will do is there was a series of Supreme Court decisions over the past several years that dealt with arbitration agreements in the employment context. And the long and the short of that series of cases was that if an employer made as a condition of employment, you have to waive your right to things like a jury trial, participation in a class action, or some other waiver of your right to go to a courthouse and prosecute a claim against your employer, the Supreme Court said, as a matter of contract, that's fine. You can do that. An employer, if that's the way you want to set up your employment relationship, that's fine. One such case in this area was Epic Systems, where Mr. Lewis argued that private arbitration agreements in the employment context violate the National Labor Relations Act. Supreme Court said, Mr. Lewis, you're wrong. It does not. What the PRO Act would do would be to basically overturn the Lewis decision and allow people to bring employment-related claims in court, including class actions. So up to this point in time, if you wanted to have an arbitration provision in your handbook, in your employment agreement that says, employee, if you want to sue us, you can't go to Montgomery County, you can't go to federal court. Instead, you're going to have to go to an arbitration in front of some arbitrator. The PRO Act would overturn that and preserve to the employee the right to go to court and the right to bring a class action. So that will be another monumental shift in the employer-employee relationship. Okay, next slide, Amy. And this one is kind of a return to the purple communications decision of the Obama years. Under the PRO Act, employees could use the employer's email system for union and other organizing activities absent a compelling business reason. And any violation of that provision, i.e., you can't use our system to organize, would be the subject of the penalties, the personal liability, and the liquidated or punitive damages that we just spoke about. Contemplate this for a moment. Of the 124 people in the audience right now, everyone has an email system. Email systems require storage. Email systems are expensive to administer. And the PRO Act would basically say you have to provide space on that system for unions to organize your employees. And unless you can show a compelling business reason, and so far as I have been able to discern, nowhere is the compelling business reason defined, then it's my view that employers are going to lose that compelling business reason argument 99 times out of 100. So you will be now providing resources and access to your workforce, to a union, to organize your employees so that they can collectively bargain against you. That is a fairly dramatic proposition. No. And the final element of the PRO Act that I think is important is a change in what is considered an independent contractor. And I understand you're going to have someone speak about that in the near future. But under the PRO Act, they are going to borrow the definition of an independent contractor from the state of California. And everyone on this call knows what the state of California means in terms of employment laws, better known as the ABC test. And so the ABC test means that the person who is considered an independent contractor is free from the control and direction of the performance of the service. Okay, and I'll explain by example in a minute. The second element, B, is the service is performed outside the usual course of the business of the employer. And 3, the individual is customarily engaged in that trade, occupation, or business. So let's contrast a group of temporary employees that we hire to help with a busy time. Let's say it's a Christmas ramp up. There's a lot of shipping going on, and we want to bring a bunch of people in to help with that effort. We're going to call them independent contractors because they're not going to be here long. We're hiring through some agency, and they're just not our employees. And contrast that person with the plumber who comes in to repair a plumbing issue. That's a person who, when they walk in the door, we don't tell them what to do, so they are free from our control and direction. We are not in the plumbing business. That plumber is. And we don't conduct plumbing repair services in the context of our business as a general proposition. So under this ABC analysis, the people we bring in to help with the ramp up for a busy time would never satisfy that ABC test, because they are helping us under our control and direction to work in our typical business. They are unlike the plumber who is coming in and we're not telling them what to do or how to do it. So that is really the sum and substance of what the independent contractor test will look like. Amy, I think that's the last slide.
It is.
Okay. I wanted to try to move somewhat quickly through those materials to give you some practical observations as I see them and give you some opportunity to ask me questions. If you think of the scales of justice, under the PRO Act and under the Biden administration, picture the thumb of the federal government holding the union side of that scale firmly against the desktop. It is not going to be a balanced proposition for the next 4 years. This is an administration by, for, and with organized labor. So from an employer perspective, I would encourage you strongly to pay attention to this situation now. So when the people try to organize your business, your supervisors are going to be trained, they're going to be aware, and we're going to be able to get the jump on the union before they gain any traction in getting cards signed. So I think, are there any questions at this point? I think you see one. The question comes, and I'll repeat the question. Having to let unions use your email systems to organize is odd. Most companies have policies that talk about the company's right to monitor all electronic communication, that the employee should have no expectation of privacy. So does that mean that the employer would be able to monitor all union communications, or would that be considered some kind of violation? That is a fabulous question, and here is the answer. You probably could monitor communications under your general policy. The union or someone who is subject to some sort of disciplinary action, they're going to file an unfair labor practice charge against you saying, you monitored my conduct on the email system. You knew I was pro-union and you gave me disproportionate discipline because of that. So I think the actual monitoring may not be a violation. I think the use to which a union can put it will be subject to a lot of expense defending unfair labor practice charges.
Yeah, and then the other question we have, Sean, is how are the unions spinning the PRO Act to make it sound, you know, not terrible for the employers and not so completely pro-union?
Here's what I want you to put a mental image in your head of a steamroller. And that steamroller is rolling down a hill against employers, and the unions really don't care what it looks like. Right now, they have the stars aligned as well as they're ever going to have them. They've gotten the PRO Act through the House. They've got a 50-50 Senate. They've got Vice President Harris to break a tie. So this is going to be about raw legislative muscle right now. And I don't think they really care if it sounds beneficial or not.
Yeah, I think that's what we saw under the Obama administration. If everybody remembers EFCA, the Employee Free Choice Act, the unions did not care at all that it was pro-union piece of legislation. They felt like they had worked hard to get President Obama elected, and that was their payoff. And I think the feeling now is probably somewhat similar.
It really is, and I think it's the 13 or so senators from right-to-work states who are Democrats. They are going to be in for a very uncomfortable time because their constituents, the business communities, are going to be all over them to vote against this. So we'll see how the Joe Manchins and people like that respond.
Got a question about what specifically would you recommend around training?
As Amy and I have done in prior years, you want to train supervisors so that they understand what the National Labor Relations Act is, what their significance is as a supervisor under that act, and what steps they can take to lessen the risk of union organizing activity.
Yeah, you want to make sure your supervisors know what to look for, because there are telltale signs usually when a union organizing campaign is coming. But you also want them to know what they can do and what they can't do, because we've seen, so full disclosure, Sean and I worked together for a lot of years at what was then Pepper Hamilton, is now Troutman Pepper. So we saw a lot of supervisors step in a lot of stuff and make a lot of big mistakes in union organizing campaigns. And when you had 42 days for the campaign, you could usually undo those missteps and those mistakes. Not always, but usually. When you only have 20 days, it's a lot harder to do. So if your supervisors are well prepared going into this to know what to look for and what they can and can't do, you're going to be in much better shape.
Yeah, and successful union organizing campaigns typically are the result of poor supervision, unequal administration of policies, supervisors that people are fearful of. It's rarely about the economics because the market determines what the economics are going to be.
Right.
So Amy, this is Kevin. I'm jumping in here. And so this reminds me of PSO last year when a new kind of thing came out and people needed to get up to speed. If people are interested in seeing if we could develop like a virtual workshop for your managers, just type it in the chat just so we see there's interest. And I'm sure Amy will figure something out, but let us just know if that's something of interest. This sounds pretty, sounds significant, doesn't sound real significant. So let us know if that's something you'd be interested in.
Okay. And then one more question, I'm gonna let you go, Sean. I know a lot of employers are used to the idea that there's you have to have a minimum number of employees for certain legislation to apply. Is that the case for this PRO Act? Or would it potentially apply to all employers?
It would apply to all employers, so long as you affect interstate commerce.
And that's pretty much everybody.
Pretty much everybody. You are in the club.
All right, well, thank you so much. This was really helpful. And as Kevin said, if you have interest in doing some union avoidance training, that's certainly something we can help you with at MEA. So so Sean, thank you so much for joining us this week. It was good to see you.
Thank you. Likewise. Take care.